On Law Weekly today, we assess the judiciary in the outgoing year. We also look at the issues of delay, especially in the administration of criminal justice. Our guest is Senior Advocate of Nigeria, Professor Taiwo Osipitan. That's the lineup. Hello and welcome. I am Shola Sheyeli. My guest, Professor Taiwo Osipitan, holds the LLM degree of the University of London. He joined the Faculty of Law of the University of Lagos in 1983 as a lecturer grade 2 and rose to become a professor of public law in 1997. He was conferred with the rank of Senior Advocate of Nigeria in 2002. Although he specializes in commercial and public law, he has litigation as his chief area of interest and has handled several cases across the country. In this interview, I began by asking his assessment of the judiciary in the year 2016.
In terms of being able to decide some cases speedily, particularly those that deal with election petition, I would say that the judiciary has done very well in terms of being able to keep within the timeline. Also, some civil cases which are of importance were also determined speedily and efficiently by the judiciary. Well, we are also looking at judiciary in terms of criminal cases. In that area, it will appear that the expectation of Nigerians have not been met in terms of a speedy dispensation of justice in accordance with the Administration of Criminal Justice Act. But then, the learning process, as they settle down to study the Act and apply it, I believe that with time, they would be able to do very well. So, by and large, the judiciary has not done very well. That has not done badly in terms of discharge of its caseload, deciding cases as speedily as possible within the limits and the resources available to the judiciary.
How about the perception of the judiciary in the year 2016? It was the year that the DSS invaded the homes of some judges, and when you read about the amounts of monies that were recovered in the homes of those judges, how did we get to that stage?
Well, it's a very, very unfortunate event. But for me, insofar as no judicial officer has been convicted, I would still say that each of those persons involved is entitled to presumption of innocence. But to the layman on the streets, I think the image of the judiciary has been really battered and discredited on account of what has happened. But that's from the angle of the layman. But again, you're looking at judiciary that has so many fine jurists. If for any reason few judicial officers are alleged to have been involved in activities which are said to be corrupt activities, money laundering, and so on and so forth, that would not be a reason for saying that the whole judiciary should be sanctioned or should have its image smeared. Because don't forget that the judiciary is also the third arm of government and the last hope of the common man. So we cannot afford to smear the image of the judiciary and at the same time expect the common man to have confidence in the judiciary. So there's need for care and caution in the way we interpret things and in the way we draw the judiciary back. Because the DSS and other agencies that did some things that are capable of tarnishing the image of the judiciary, when they have civil cases as well as criminal cases, it is the same judiciary they go to. When they need to prosecute people for terrorism and money laundering, it is the same judiciary they go to. So if you smear the image of the judiciary, then you have issues of going back to the same judiciary that you have passed a vote of no confidence in to still do justice to your case without fear or favor. Indeed, some of those steps taken were meant to send fears into the minds of judicial officers, sends a wrong signal. But I believe that with time, the judiciary will pick up itself and dispense justice courageously without fear or favor.
But what do you make of reports that some judges have monies in their accounts that far exceeds what they earn lawfully? How do you explain that?
Well, I have not been privileged to see the statements made by the judges. It is when you see the proof of evidence and you see the statements made by them that you will indeed be able to know whether indeed they have been able to explain or they have not been able to explain. I can't hold brief for them. But again, until I see the proof of evidence to see whether indeed they confessed that the money that they took, is that the money found on them are product of corruption. Quite honestly, one cannot say anything until I see those documents.
Let's look at the role of the NJC in the appointment, promotion, and discipline of judicial officers. Because some people say that this was what necessitated the intervention of the DSS. That if the NJC had acted swiftly to deal with petitions written about some of these judges, then we wouldn't have seen the kind of things that we saw happen in 2016.
Well, within the limits of the law, I think NJC is trying its best. But I think also that the NJC is overwhelmed with the volume of petitions against judicial officers. This volume of petition may not be unconnected with the fact that some judges have no business on the bench. Some of them should not have been appointed in the first instance. But majority of them are still fine judges compared to what you have in other jurisdictions. They are indeed very, very efficient and fine judges. But again, the few ones that are bad have managed to attract so many petitions that have to be treated by NJC. And I do not think NJC has enough capacity, manpower, to be able to deal with these petitions. I'm not too sure. But again, what we have now is what they call harvest of petitions. Some of the petitions that are going to NJC are issues, they deal with issues that ought to have been taken up by a litigant on appeal. A litigant loses a case. Instead of appealing, all he's going to do is to go to NJC. In some cases, he has gone an appeal on the same issue and is also concurrently pursuing the same issue before the NJC. So if you look at the case docket of NJC, I believe that you'll notice that there is an upsurge of cases of petitions coming before the NJC. Again, those who go before NJC may not have gone there following due process. For you to have a petition properly before the NJC, not only must you write, you must have what they call an affidavit to verify the content of the petition. In other words, you must go to court and swear on oath that the content of your petitions are correct. And the effect of that is that if it's not correct, then you can be liable for perjury. But then people write petitions. I don't know whether DSS in forwarding petitions to NJC, whether it accompanies him with the verifying affidavit. If you have not followed due process, quite honestly, you cannot blame NJC for not being swift. But I happen to know that judges have been sanctioned by NJC. Some have been reprimanded. Some have been removed from offices based on the recommendation of NJC. So one would say that NJC is doing, and some have been cleared. Now the issue about NJC is that when a judicial officer is dragged to NJC, even before the trial, the information is leaked to the press.
Is that really a bad thing that the news gets published?
Well, yes and no. Well, you can talk about freedom of information that enables you to access information. But then what I find out is that when judicial officers who appear before NJC are cleared, the same machinery which was used in broadcasting or publicizing somebody who is dragged to NJC ought to be used to let the world know that this person has been cleared. I had cause to defend a judge before the NJC. The trial was prolonged, very tormenting, and very traumatic for the judge. But at the end of the day, the judge was discharged and the petitioner was told that his petition is baseless. But nobody has said anything about it. But when the judge was being taken to NJC, the whole world knew. I think it's only fair that whatever is good for those who are sanctioned by NJC is also good for those who have been cleared, so their family members can be rest assured, and their friends who heard about them being taken to NJC can now know that this person is not corrupt, this person is clean. Again, because of the harvest of petitions which we are having against judges, I believe it's time that you start looking at what sanctions do you mete out to those people whose petitions are found as being frivolous and unmeritorious. These petitions sometimes are written by lawyers and signed by lawyers. Sometimes the lawyers draft the petition and they're signed by their clients, but the language of it is that of the lawyer. I'd like to see a situation where lawyers who write frivolous petitions against judicial officers are dragged before the Disciplinary Committee of MBA and sanctioned for misconduct or infamous conduct. Because it's an infamous conduct for a lawyer to now write petitions which are unsubstantiated against judicial officers. Bearing in mind that whatever you do, whatever you write against a judicial officer affects the whole judiciary. So I think lawyers and those people whose hobby now is to write petitions against judges, there's need for us to find something to keep them busy.
But why is that not happening now? Why are we not seeing lawyers get sanctioned when they write frivolous petitions against judges?
I loved a situation whereby NJC, after clearing a judge of allegation of corruption or misconduct, and finds that there's no merit in the petition, and finds that the petition is either vindictive, oppressive, or designed to harass or irritate a judge, NJCs can make a recommendation to MBA to look into the conduct of the lawyer with a view to sanctioning the lawyer.
Let's round up with the issue of delays that still persist in our courts despite this, the use of the Administration of Criminal Justice Act of 2015. A lot of Nigerians would like to see convictions or acquittals, as the case may be, especially in all these high-profile cases, and we didn't see a lot of that in 2016. In fact, we only saw one when you talk about that of the former DJ of Nemasa who was convicted, and he's currently appealing that decision. Why do you think that we still have these issues of delays in our courts?
We have what they call, we don't have a specialized bar or a specialized bench. In those jurisdictions where cases go on and are decided speedily, some courts are devoted to those high-profile cases. You also have lawyers who are experts in criminal law. They are not practicing anything but criminal law. So they have all the rules of evidence and procedure at their fingertips. If a person is a specialist in an area, the judge is a specialist in an area, you also have lawyers who are also specialists in those areas. It makes the work move faster. But what we have is a non-specialized bar and non-specialized judiciary. The same judge that tries criminal cases does matrimonial cases, does landlord cases, landlord and tenant cases, does commercial cases. He or she cannot cope. Then of course the prosecution are either not ready or the defense also not ready. They will plead for one adjournment or the other. But I believe that it's a learning curve. As we settle down in 2017, I'm quite optimistic that more of these cases will go on and will witness either conviction, which Nigerians want to see, or acquittals, which Nigerians don't want to see. But judges have been trained to dispense justice without fear or favor, devoid of sentiment or emotions.